This is an interesting story about how I helped a client who came to me whose initial expectations were rather low, but in the end we got an outstanding result for this client. This particular client was referred to me by a lawyer that I know, and the client was typical of diminished value cases. This is a client who is a successful business owner. He's in the construction industry and owned a 2007 Lamborghini Murcielago, which is a vehicle that originally retailed for about $345,000. And here's what happened to him. He was in a gated community and he was rear-ended by another driver. The police weren't called to the scene of the accident because both parties cooperated and exchanged insurance information. So they didn't think that the police were necessary. And the owner of the Lamborghini came to me because his insurance company paid to repair his car and he had a $10,000 collision deductible. So he was out $10,000 for the repair to his car. And he wanted me to help him get the $10,000 back. I interviewed him about all of the facts of the case regarding his ownership of the vehicle, how the accident happened, his insurance company, and the insurance company of the party that caused the accident. And then I started to investigate the case. And here's what I found out. My client's insurance company and the insurance company of the at-fault driver participated in binding arbitration. And the arbitrators rendered a decision that my client was at fault for the accident. And I knew that was incorrect. And what had happened is that because there was no police report and insufficient statements taken from the two drivers, they just made a mistake. But what happened is that my client's insurance company was then stuck with that decision. They could no longer enforce their subrogation rights against the at-fault insurer. Then I took a look at my client's vehicle history and suggested that we make a diminished value and loss of use claim on his behalf to the at-fault insurance company. I hired a professional appraiser and gave him all of the information that I had regarding the accident, including the invoice for repair, which cost about $62,000. The vehicle was out of service for about 125 days. It had to go to 2 different shops to have the repair performed properly. So we submitted a demand to the at-fault insurance company for its $100,000 policy limit. Between the two claims, diminished value and loss of use, we felt that the value of my client's claims were greater than the $100,000 policy limit, the $100,000 property damage liability policy limit of the at-fault driver. But we got some pushback from the at-fault insurance company. It said, look, we're not going to honor your claim because we have a pending subrogation claim against your client's insurance company or coming from your client's insurance company. But I explained to them that because the arbitration that they participated in was binding arbitration, my client's insurance company could no longer make a subrogation demand, and that they were required, or that at least they should, tender their full $100,000 policy limit to my client. After some persistence, they eventually did. And when my client realized that instead of just getting him his $10,000 deductible back, I got him a $100,000 settlement, he was extremely pleased. And it's one of my favorite stories because the client was an extremely gracious man and he really appreciated the efforts that we made on his behalf. And it's one of my favorite stories about diminished value practice. It's an area of my practice that I thoroughly enjoy. I am lucky to be retained by a wide variety of interesting people, business owners, professionals, engineers, lawyers, doctors, all people who have high-end or exotic cars, RVs, or motorcycles that are in an accident and repaired, and I can help them with their diminished value and loss of use cases. I hope you find this story interesting.